Every litigator has done this work. A matter lands on your desk with 3 years of email traffic, hundreds of file notes, witness statements that contradict each other, contemporaneous documents from 4 different parties, and a chronology that needs to be on the partner's desk by Friday. The chronology is the spine of the matter. The pleadings reflect it. The opening statement walks it. The cross-examination references it. The closing weaponizes it. And building it, traditionally, is the kind of work that swallows weekends. This is Foundations Episode 5, a 5-step protocol for assembling a working chronology from fragments. Not a week, not a junior's 3 weekends, an afternoon. First, what changed? 20 years ago, building a chronology meant a folder of letters and a typed timeline. The volume was manageable. A senior associate could do it on a Saturday. The method worked because the matter fit the method. Now, a contested commercial matter arrives with tens of thousands of emails, message threads across 4 platforms, file notes in 3 different systems, contemporaneous documents from every party, witness statements signed years apart, and the volume is genuinely impossible by hand. The matter has scaled. The method, mostly, hasn't. We hand it to a junior. The junior spends 3 weekends on it. The result is incomplete. Pivotal entries are missing. Contradictions between sources go unnoticed. The chronology you walk into mediation with is the 3rd best version of itself. Claude solves the volume problem. The method we'll walk through gives you the chronology you'd want in the time you have. You still own the judgment. Claude does the assembly. 5 steps, from fragments to spine. Step 1. Inventory. List every document type and source. Get the universe of fragments visible. Step 2. Extract. Pull every dated event, communication, decision, action, and meeting into one structured table, source anchored. Step 3. Order. Sort by date. Flag inconsistencies. Mark uncertain entries. Step 4. Annotate. Add the legal significance of each entry against your case theory. Step 5. Verify. Spot check against source documents, always. Every pivotal entry, every flagged uncertainty, every contradiction. 5 steps. The first 3 are mostly Claude. Steps 4 and 5 are mostly you. Together, they take an afternoon, not a week. Step 1. Get the universe visible. Before Claude reads a single document, you write a 1-page inventory, not the chronology, the inventory. Every source of date-anchored information. Email threads from this domain, file notes from this matter folder, witness statements signed and dated, contemporaneous handwritten notes, board minutes, contracts, anything dated. Then for each, the format and the volume. This is 15 minutes of work. It feels like delay. It isn't. The inventory is the architecture. Get it wrong, miss a source, and Claude builds a chronology with a hole in it. You won't notice until cross-examination, when opposing counsel produces the file note you didn't know existed. You can't extract from sources you haven't named. Name them first. Step 2. Extract every dated event. Now Claude. Upload 1 document type at a time. Ask Claude to pull every dated event into a structured table. Date, event, source document, source reference, key parties, and notes for context. Do this iteratively. Emails first, then file notes, then witness statements, then contemporaneous notes. Each pass adds rows. Don't try to feed Claude every source at once. 1 source type, 1 focused prompt, 1 structured output. Then layer. The extraction prompt is straightforward but specific. We'll come back to it in a few slides because it's the one most worth getting right. The discipline is 1 source at a time. Layer the outputs into a single working spreadsheet. By the end of step 2, you have the raw chronology, before you've sorted, judged, or annotated anything. Hundreds of rows, source anchored, every cell traceable to a document. Step 3. Order, then find the contradictions. Sort by date, the first cut. You now have a rough timeline. Then ask Claude to find every entry where two sources contradict each other on the same event. Different dates for the same meeting. Different attendees recorded. Different decisions reached. The same email thread referenced two different ways in two different witness statements. The contradictions are where the matter usually turns. 20 years of doing this manually meant rarely catching them all. The volume defeats human attention. Claude doesn't have that problem. Claude reads every row, holds them all simultaneously, and surfaces the conflicts in minutes. The contradictions are the case. This is where you earn your fee. The protocol gives you back the time to do that work instead of the assembly. Step 4. Annotate the legal significance. The chronology is now ordered. The contradictions are flagged. The next layer is judgment. Walk Claude through your case theory. This is what we say happened. This is the breach. This is the relevant statutory framework. Then ask it to mark each entry: pivotal, supporting, contextual, irrelevant. You're delegating the categorization, not the strategy. The case theory stays with you. What you're doing is asking Claude to apply your theory consistently across 1,000 rows, in a way you don't have time to do alone. This is the same skill we covered in episode 5. Externalize your judgment criteria. Let Claude apply them at volume. Then review the output for the calls you'd make differently. The memo doctor methodology applied to the chronology. By the end of step 4, every row knows whether it matters. Step 5. Verify, always, every pivotal entry. Claude has source anchored every row by document and reference. Now you spot check. You don't verify everything. You verify the entries marked pivotal, the entries where Claude flagged uncertainty, the contradictions. You go to the source document. You confirm the date, the parties, the wording. The verification protocol from the hallucination files episodes applies here in full. The chronology that goes anywhere, pleadings, mediation brief, witness preparation, has been verified row by row at the points that matter. The hallucination files exists because this step is non-negotiable. A hallucinated date in a chronology that goes into a court filing is the same risk as a fabricated citation. Treat it the same way. The extraction prompt. Step 2. Attached. An email thread, file notes, or witness statements. Extract every dated event into a table. 5 columns: date, event, source, parties, notes. Then 4 rules for the rows. If the date is approximate, mark it with a circa tag. If the event is reported by a different party than the source author, note per name. If 2 sources disagree on the same event, include both rows and flag the contradiction. And the line that does the most work. If you are uncertain about a date or party, mark it uncertain rather than guessing. The uncertain rather than guessing line is the same one we put on every Foundations prompt. It tells Claude that admitting uncertainty is a valid output, not a failure. On a chronology that goes into pleadings or a brief, that line is the difference between a usable working spreadsheet and a confident hallucination. Run the prompt once per source type. Layer the outputs into a single working spreadsheet. Claude's table becomes the chronology. Now the caveat. This protocol does not replace your case theory. Don't ask Claude what your case theory should be. Don't ask which inconsistency wins. Don't ask which contradiction will land in cross-examination. Don't ask which entry the partner will find most important. These calls are yours. They are why someone hired you. What Claude does is assemble. You decide what the assembly means. The chronology shows you the events. Your case theory shows you which events matter. Claude can apply your theory at volume. Claude cannot generate it. Don't confuse the two. The protocol is genuinely powerful and genuinely limited in the same breath. The power is in the volume. The limit is in the strategy. Stay on the right side of that line. The chronology was always the spine. Every contested matter sits on a chronology. The pleadings reflect it, the opening statement walks it, the cross references it, the closing weaponizes it. Until now, building the spine took longer than testing it. Most of the senior judgment on the matter was applied to a chronology built on a junior's third best effort in the time available. The protocol flips that. The spine takes an afternoon. The case theory takes the time it deserves. The judgment gets applied to the chronology that should have existed all along, instead of the one that fit the time. Coming next, the hallucination files number 2. 3 months of new sanctions cases, the patterns the courts are settling into, and the protocol updates that follow. Subscribe so you don't miss it. That's the episode. See you in the next one.